I was asked to tell you all a little bit about myself. Gary pretty much summed it up. So I am actually from Mount Vernon, graduated from high school here. I have degrees in criminal justice and political science from Murray State, and my law degree came from SIU. So I've now been doing this for a little more than 10 years. My practice, as Gary said, mainly focuses on mineral law. I represent coal and oil companies with issues involving their land and lease acquisition. I represent the crude purchasers. So most of these guys that are operators and produce the oil, they immediately sell it to a crude purchaser. So I help them. I write title opinions for the crude purchasers that tell them ultimately who to distribute the proceeds from that oil to. Sometimes I represent landowners and mineral owners, helping them get title vested where they need it to go. I represent a lot of these people before the Department of Natural Resources and the Illinois EPA. And then, as Gary said, I also work with IOGA, which is the trade association, and we work on lobbying at both the state and federal level. So, in case you didn't need me to tell you that, it's not real exciting and real glamorous stuff, right? Nobody's writing books and making movies about what I do, but this is an industry full of good people and good, hardworking people, and so on the days where there is a reward, I guess it's in helping them solve problems and ultimately make a living. So they asked me to talk to you guys today about the land and legal aspects of the oil industry. So just initially, I mean, there is a very large body of law governing this industry, and every oil well from the beginning stages to when oil comes out of the ground and is sold is going to run into a significant number of legal issues, and those are going to include basics as who owns the oil. It's going to involve leasing, going to involve acquisition and permitting. You've got compliance with regulatory agencies, and then again, who gets paid for it. So we'll go on to substance here. I do want to say, stop me with any questions as we go along. I'd much rather discuss something that's of interest to somebody than just stand up here and talk. So a little bit of like a social studies review. So in Illinois, we've got a complex system. The framework is as you've learned your entire life. Our body of law has been developing for more than a century. I'm sure you've heard the dates, but we've got coal production back into the late 1800s and oil into the early 1900s. And sort of why we have this body of law, well, it's because fossil fuels are a valuable commodity, right? And so throughout history, valuable commodities basically equal conflicts, and conflicts equal legislation, regulation, and litigation. Of course, technology also drives some of the evolution in the law. So our system is really one of the more complex and comprehensive systems. I think a lot of the operators would say it's one of the more oppressive systems in the country. It's really hard to get anything done here. Most of our principles, our early principles anyway, are gathered from the more traditional mineral production states. So we're talking about Texas, Oklahoma, maybe Kansas, and the basic framework is we have the legislators do their jobs. Their job is to make laws. They usually grant the authority to an administrative agency to enforce the law. The agency issues regulations, and in isolated instances, then we have the courts that interpret those the legislation and the regulations. So in our area, the federal statutes that we deal with that intertwine with the state regulations and the state statutes are usually environmental or safety related. So again, we're talking about the EPA, maybe OSHA. And just like you've learned your whole life, usually the federal laws will supersede the state laws. Okay. So what are minerals, right? Basic concept, but we actually have numerous court cases that tell us what a mineral is and what a mineral is not. So generally, we're talking about coal, oil, and gas. There are other minerals. Other minerals they're too numerous to mention. Two that I pulled out as examples are the rare earth minerals, which I don't really know much about. I think they all have a high metal content, and they all end with ite, like ITE. There is, I heard Jones say Hicks Dome, there's a significant, or I think there's believed to be a significant deposit of rare earth minerals down the southeast part of the state. As far as I know, it's undeveloped, although I do think I heard the other day that maybe somebody's looking into a permit to try to extract some rare earth minerals, whatever they may be. Fluorspar is another example that actually has been produced. For purposes of our conversation, and really generally speaking, rock and sand are not minerals. They're not considered minerals for, at least as far as the law is concerned. Okay, so moving on, once we've identified what a mineral is, then the question for the industry is before we can extract them, we have to know who owns them. So a couple of concepts in mineral ownership. You'll hear, particularly in Southern Illinois, people like to say, well, I own the mineral rights. I own the mineral rights. So, I own the mineral rights. Well, what does that mean? That usually doesn't mean what they think it means. First concept, you've probably heard this today already. I apologize if any of this is redundant, but minerals are considered real estate, okay? They can be bought, sold, transferred, mortgaged, lost, all in the same manner as you can buy, sell, mortgage your home or your farm or any other piece of property. Second concept, ownership of those minerals can be separate from ownership of the surface. If you haven't heard that yet today, that's something sometimes I'm surprised that people are surprised to hear that. So what that means obviously is one party may own the surface and the farmland, and another party or multiple parties own the oil and gas, coal, those other minerals under the surface. And in our area, the areas Joan was showing you on the map where there's traditional mineral production, it's rare to find a tract of land that is not severed. Okay, so quite typically the surface owner may own a portion of the minerals, but very rarely owns all of them. Okay, third concept, owners of those minerals underneath the ground can be owned by separate parties. So it's also common that the coal is owned by one party, the coal is owned by one party, oil and gas is owned by a separate party. Perhaps even those other minerals are owned by a third party. It can get really confusing. So when that happens, we call that a severance. I'm going to talk about severances. You're going to hear me say the word severed. Severances occur through conveyances, or they can occur through a reservation. So the example of a conveyance is I sell you the minerals. The farmer or the surface owner can simply sell the minerals to an additional party. The example of a reservation is exactly the opposite. I might sell you the farmland, but I'm going to keep the minerals or keep a portion of the minerals. So that's how the initial severances occur. After the initial severance, the minerals can continue to be transferred either through further conveyances or through death, which is, the classic example is I die owning minerals and I leave a will, dividing them up amongst my family members. Okay, so the severance obviously creates two different interests, right? And we call those estates. So you've got a surface estate and you've got a mineral estate. And quite frequently there's conflict between those two estates because extracting the minerals requires use of the surface. You see the tank battery here. Typically, the surface owner, especially in situations where he's not going to benefit in one bit from the oil well going in, is not going to be happy about giving up that much ground for a tank battery and lease roads and pump jacks. So here's what the law says. The law says that generally a mineral owner has the right to reasonable use of the surface to extract the minerals. There are no black and white rules as to what the word reasonable means. So in cases where this makes it to litigation, which from my perspective is the only guide I have sometimes, reasonable is a case-by-case basis, and it takes into account what's going to be done. It takes into account the nature of the land that will be affected, the value of the land that will be affected. I guess the only there is no black and white rules, but the only thing I would say is reasonable doesn't mean that we're going to put one well, one tank battery, and one leash road across 40 acres and still have the right to bulldoze the entire 40 acres, okay? There are also protections built in for the surface owners. So in the regulations, there's setback rules. You can't have your wells and tank battery sites within a certain number of feet of existing buildings. The operators are always required to pay crop damages. And as far as where the locations will be, there is a statute called the Drilling Operations Act, and that basically requires the operator to at least make the effort to meet with these surface owners and discuss the locations of these leash roads and other surface facilities. It also requires compensation for any damages that are done. So I guess the moral of the story on the surface estate versus the mineral estate, maybe for you all, is if you're buying land and you're in an area that has the least bit mineral production, you better find out what you're buying, because in that situation, it really is buyer beware. Surface owner is going to buy whatever the surface owner he's buying from owns, and that may be the surface all the way to the center of the earth, and it may be nothing more than the surface. You take it subject to prior reservations and the rights of the mineral owners. So once they figured out who owns it, well, most mineral owners, even if we know, or even if they know, even if they do own it, they don't develop it themselves. Most everybody lacks the expertise to do that, and it's very, very expensive. Drilling of an oil well can cost hundreds of thousands, if not millions of dollars. So owners typically lease the right to explore for and produce the minerals to an operator. So leases can be very short, they can be horrendously long, but basically we look at three real important terms here. The first one is actually the term of the lease, the length of the lease. So you have a primary term that's going to say this lease is valid for 1 year, 2 years, 3 years, whatever it is. And then it'll have the ALTA. ALTA stands for as long thereafter. So it's 1 year, 2 year, 3 years, again, whatever the primary term is, and as long thereafter as oil and gas is produced. So that lease is going, as long as production is obtained within the primary term, that lease will continue until production ceases. Another important term in the lease, which I'm sure you've all have heard at least, is royalty. So royalty is the fraction of the oil produced that the mineral owner will be entitled to. So in most cases in our area, we're talking about it's an eighth. So the royalty owner will be entitled to 1/8 of the proceeds from the oil. Royalty comes off the top and is expense free. You typically do not pay any expenses in the drilling and completion and operation of the well if you simply are a royalty owner. And then a third clause that kind of goes along with the theme of the severance and the division of interest is the lesser interest clause. The lesser interest clause simply means that if you own less than all of the minerals, you will not, your royalty will be reduced proportionately. So in a situation where there are multiple owners of the oil and gas, say I own a quarter of the oil and gas, the lesser interest clause says, well, if I sign a lease that says an eighth royalty, I get a quarter of an eighth, not the full eighth. Okay, so back to determining mineral ownership. This is how these guys go about this. The operator is normally going to hire a landman. Landman is usually a non-lawyer, although in larger companies it may be a lawyer. Landman is also usually a contractor. Although again, in larger companies, they may have an in-house land department or an in-house landman. Landman, so his job is what you see here. He's going to go out and he's going to review the county records. He's going to look at land records, death records, court records, internet sources that we now have, Ancestry, Social Security death indexes. We have findagrave.com, which is really helpful. And then depending on what he finds, he may end up in other states and other counties trying to track down whatever leads he has as to who is the ultimate owner of the minerals. Once he's got all that information, he puts together a chain of title, determines who these owners are, and then he goes ahead and contacts the owners to obtain leases and negotiate the terms. And then in some cases, if it's necessary, they'll negotiate with surface owners for any necessary surface use agreements. When the landman is done, or he's gone as far as he can go, usually they'll turn it over to a title attorney. So this is basically what I do. What the title attorney does is we review everything that landman has done. So they typically will do a title report. They'll bring us copies of their leases, copies of anything they've acquired that says why they believe they have leased the right people. We're going to conduct our own review of an abstract of title, which is generally a compilation of every document that's of record pertaining to that interest. May conduct our own stand-up search in the courthouse ourselves. We typically will do that. Once I've reviewed all of that, I issue a title opinion. The title opinion is for the operator's eyes, and it tells him who owns the oil and gas, where he's at on his leasing, and what else may need to be done to clear up any remaining issues and to ultimately acquire all the interest necessary to drill the well. We also will help resolve conflicts among owners. Those happen all the time. And then after the drilling is complete, if they make a well, then we also will submit a final or updated opinion to the crude purchaser to tell them who to pay and in what proportions. So the only thing I wanted to show, the only thing people really find interesting at this thing, we've been doing this for 3 or 4 years, is I get a lot of questions about this. So on any given 40-acre tract, we can get a ton of owners, right? This is a lease I worked on where we had 40 acres, and everyone that says RI is an owner of the minerals. And it goes on and on. And so,
what are some of those decimals?
So you can see here, I think the largest interest we had in this lease was a 1/15th. On $100,000 of oil, a 1/15th interest at 1/8 royalty is entitled to $833. There are some people in here, like there's a 179 over 2,700. There's a 1 over 1,200 somewhere. So 1 over 1,200, on a 1 over 1,200 interest at an 1/8 royalty, you're getting $10.42 out of $100,000 of oil, and so on $1 million, you're getting $104. So those are all people that had to be leased. So these guys, they did the work and they acquired these leases. It took several years. We didn't get to the different kinds of interest, but those guys stopped there. Total, they're entitled to roughly 12.5% of the oil. There were some overrides, which are also off the top interest. I won't tell you, go into it too much. Anybody ever offers you an override, take it. It's free. Okay, it's free money. Now, if you have to pay for it, think about it. But if they're offering you an override, just in general, it's free money on the oil coming out of the ground. So those overrides reduce the working interest further. So remember, if you took a 1/8 out, you got 7/8 left. So that 7/8 is what we call the working interest. If there's overrides, it comes out of that 7/8. So these folks are the ones who ended up with the working interest. So if I take this guy here, he had 46.42% working interest. By the time you proportionately reduce that for the overrides and the royalty, he actually ends up receiving 37% of the revenue. But the working interest are the expense bearers, so he still pays his full share of expenses. So 37% revenue, 46% expenses. Okay, so I'll quit there. I was going to show you, this is really a bad day in my office when we're doing this. Like, my secretary hates me, I hate her. But after all that, if you get a 1.000 at the end, you're happy.